The CoinSource channel is pleased to have you back. International B2B payments will now be easier to process thanks to a new cooperation between Visa and SWIFT that aims to improve network connection. The transfer of billions of dollars could be made easier with this collaboration. In fact, the companies will work together to improve the speed and transparency of international money transfers while expanding the alternatives available to banks and their customers. Chris Newkirk, Global Head of New Flows Commercial and Money Movement Solutions at Visa, and Erica Losi, Chief Strategy Officer at SWIFT, were my guests earlier this week. Before anything else, I wanted to get Chris's take on the new partnership announcement since I knew he would be well-versed in the difficulties that many businesses face. It is with immense pleasure that I inform you of our alliance, which brings together two illustrious enterprises and a wealth of expertise. Together, we can improve cross-border flows to make them more transparent, secure, and data-rich. This collaboration is great and aligns nicely with our network of networks strategy, which seeks to deliver first-rate client experiences through partnering with several networks. We are pleased to announce that the SEC's case against Ripple has been granted by Judge Nat Byrne, allowing us to disclose some exciting news. In order to verify what is permissible and what Ripple is obligated to reveal, we will review the relevant records, such as their financial accounts. Unexpectedly, the SEC is being granted full authority for their petition to Compel, considering the rulings in the court's most recent filings in the Ripple v. SEC case, but with attorney Violin's help, we'll look over the papers carefully to open the door to this conversation and, in the end, help you live a life you love. Bitcoin, personal finance, and investing are some of the possible video subjects here. A few seconds ago, the button was introduced. Click it if you haven't already. From Judge Nat Byrne's point of view, February 520-24 is the important date. The SEC has requested mixed financial accounts from Ripple for 2022 and 2023. Institutional XRP sales earnings following the filing of the case are liable to fluctuate. Two of the questions are freeform and require a response. Currently, there is a wave of objections to the application, and two of these questions concern the specifics of the contracts that regulate institutional sales after a complaint has been filed. Therefore, the court addressed the pertinent parties' cross motions for summary judgment on July 13, 2023. Rulup was found guilty by the court of offering and selling securities in violation of Section 5 of the Securities Act of 1933, and the parties have just resolved the details of the remedy. When it made sales of XRP to institutions, it was appropriate to set timetables for such discoveries, if you believe it. This is where she will discuss the last motion to compel, which was submitted over 3 years ago. However, that motion dealt with experts and was unrelated to the financial documents at issue or Ripple's involvement in transactions that followed the complaint. Taking into account the current circumstance, the defendant's financial condition is a major factor in determining an appropriate sentence that takes into account the offender's behavior. The SEC is certain of this outcome based on the case's facts. It is not claiming it cannot pay any penalties, rather, it is asking for this financial information so the court may come up with a reasonable plan for finding a suitable remedy. Moreover, the discretion of the court determines the eventual punishment. If such data cannot be accessed, the financial situation of Ripple is unrelated to the decision that the court will make, and the business does not expect a finding that would substantially impact its financial situation, according to Ripple. Furthermore, Ripple is quite secretive about its financial dealings. Currently, the district judge, and not this court, will decide what factors are acceptable and reasonable to establish a suitable remedy. The court does not see any reason to obstruct the investigation by withholding potentially relevant publicly available information. Ripple is required to submit its financial reports for 2022 and 2023. Per the protection orders granting party following the complaint contracts. In my opinion, your response is lacking in the section regarding the remedies application. The parties disagree on whether contracts entered into after a complaint should be considered for determining the appropriate remedy. The Securities Act provides James with a commission. According to CRS's convincing argument, the district court ought to look at the district court's actions following the complaint when considering the appropriateness and fairness of an injunction. If the ripple effect is to be believed, the SEC should not be enjoined from continuing its post-complaint actions. In response, the court does not believe that the creation of these contracts will lead to an unjust or expensive mini-trial, contrary to what Ripple had asserted in its counterargument. When Ripple has completed its post-complaint contracts, it will receive the 3 XRP institutional sales revenues. Last but not least, the SEC states that any disgorgement estimate must incorporate the monies earned through institutional transactions that took place prior to the filing of the complaint. Another example given in this article states that when the parties to a transaction legally attach themselves to one another, it is then deemed that the acquisition of a security has taken place. In this scenario, the relative significance of Ripple's reaction is not at dispute. Reason being, the SEC has presented enough proof to imply that the court might use this information to inform its remedy. His legal assertion is disagreed with by Ripple's, who insists that the parties could have entered into their contracts without any explicit or non-existent exchanges. Rather, the question of whether Ripple should be obligated to answer this question is the disputed one. This verdict requires Ripple to answer to an interrogatory stating that the request to serve an additional interrogatory by the Securities and Exchange Commission was fully authorized and that the court had granted the request. Judge Net Byrne has a history of issuing orders that have been problematic for the SEC, and this issue has persisted despite the court clerk's polite requests that the motion be refused. This case involves the court turning over financial statements, contracts entered into after the complaint, and revenues from institutional sales to the SEC. It was our expectation that the SEC would prevail in this matter, but you won't believe what happened next. A stunning turn of events has occurred. They can move forward with remedies and potentially even obtain an injunction now that they have scored 3 things. Please tell me if you still believe this has any chance of succeeding and if the judge will side with the SAIC because of the items they will obtain and the possible increased penalties that would ensue. I'm hoping we can come up with a solution soon, but these documents need to be processed and all that good stuff. Consequently, we will just have to watch what occurs. It is highly likely that the most of it will be sealed. Therefore, we will not have direct access to Ripple's financial accounts. Nevertheless, perhaps the conversation surrounding them will shed information on their future. In case we need to start all over, this is a short document, only 3 pages, and I'll put a link to it below. Any of this discovery has a deadline of just 1 week, on February 12th. Consequently, the timeline is currently proceeding as planned. I am crossing my fingers that the following few weeks bring a bit more activity here as we move through this stage. I hope you have a fantastic remainder of the day and an even better start to the week ahead. It will be in the next one that we reunite. Naturally, I intend to provide it to you before the deadline. I trust this has been of some use to you. We ask that you subscribe if you have found any value in our content. Muchas gracias, depart.